Good morning, dear students from Modern University. It is a great pleasure for me to be with you this morning to address you on this very important topic of historical developments of international criminal justice. This is my second time in Moscow, and I am here to participate in a course on international criminal justice organized by the International Committee for the Red Cross. And once again, I must say that I'm very pleased to have this opportunity to address you this morning on this very important topic. First, let me introduce the way I will present my subject this morning. Of course, based on my background, I will focus mostly on the International Criminal Tribunal for the former Yugoslavia, the Yugoslavia Tribunal, as it is known within the community of independent states. I have been with the ICTY for the past 4 years. I was initially initially I was with the Office of the Prosecutor. I then moved on to working with the judges, and now I am a defense counsel representing an accused before the tribunal. For this reason, I have I've had the chance to have a good view of the tribunal over the past 4 years, and it was with great pleasure that I will share my enthusiasm for this tribunal with you this morning. My presentation will be divided into two parts. First, I will begin with an introduction on the historical developments of international criminal justice. And then I will begin with part one, dealing specifically with the functioning, but also the creation of the International Criminal Tribunal for the former Yugoslavia. I will then follow in a second part of this presentation with the most significant issues arising from the case law of the tribunal. I will then end this presentation with a conclusion by highlighting the differences and the similarities between both the International Criminal Tribunal for the former Yugoslavia and the now better known known in the community of independent states, that is the International Criminal Court. As you know, the International Criminal Court has a statute that was adopted in Rome in 1998, and this statute has just recently entered into force in 1 July of this year, 2002. I know from speaking to many students in Moscow that many of you are both interested in the work of the Yugoslavian tribunal and that many of you have questions. I also understand that the tribunal is the object of a lot of critique from many people. And you will probably be surprised, but one thing I can tell you is that I also believe that the tribunal is far from being perfect. There are many things which can be improved. However, that being said, I must really say to you that I believe in this tribunal, and I think it is the single most important improvement, or at least a contribution to the advancement of international humanitarian law over, let's say, the past 10 years. And I'm eager to share with you this my enthusiasm for this institution. Moving on to my introduction. Before addressing the question of international criminal justice or international criminal law, it is important to say a few words about international humanitarian law. 2 weeks ago, I was in Geneva addressing a group of university international law professors who were at their beginning in terms of international humanitarian law. And what I was telling them about this body of law, first, is that it is, on one hand, very simple, and on the other hand, very complex. International humanitarian law lends itself to the most complicated and the most thorough academic analysis on one hand. Yet, international humanitarian law must be very simple. Why? because international humanitarian law must be able to be applied by a soldier, regardless of his age or experience or rank, in the most difficult of circumstances. For this reason, international humanitarian law deals mostly with people, and that makes it very interesting. As you know, public international law deals mostly with states which are the subjects of international law. Well, with international humanitarian law, it is somewhat different. The object is people. Why? Because at the end of the line, you always have a person. Whether this person is a victim, because that person is sick, wounded, made a prisoner of war, or a civilian affected by an armed conflict, or whether that person is a soldier involved in trying to apply this body of law, or at the other end of the spectrum, where you have maybe the same another person who has to face criminal charges in a court of law. At every instance, there is always a person. And this is what makes international humanitarian law so interesting. Another very important characteristic of international humanitarian law is that it was not meant to focus on repression. Repression was not the aim of the contracting parties or of the states when they met, for example, to adopt the Geneva Conventions, or when they met to adopt the additional protocols to the Geneva Conventions, and that was in, as we know, in 1977. Their aim at that time was to adopt a common set of rules to be applied by everyone in order to prevent atrocities from being committed during an armed conflict. For this reason, the wording of the Geneva Conventions or the wording of the additional protocols may appear somewhat to be difficult to use or a bit vague at times, and especially if you are trying to use it in a court of law. But nevertheless, the wording used, the conventions, the additional protocols, and the other instruments of international humanitarian law are very useful in the prevention mode. Let me give you one example. Proportionality. Proportionality will be very difficult to use in the court of law. It will be difficult to say whether an attack was conducted was proportional to the collateral damage or the unwanted damage created by this attack. This will be difficult to convict someone based on proportionality. Nevertheless, proportionality is very useful when the time comes to train soldiers who will have to make decisions with respect to launching attacks against their enemy. So, even though the aim was not repression, repression was not forgotten in the international humanitarian law instruments. For example, you have in the Geneva Conventions what we call the grave breaches. Grave breaches are the most important breaches of the conventions, which lead to what is called universal jurisdiction, or what is also understood as being the right of any state to put under trial someone who has committed a grave breach of the convention. Today, of course, we will focus on repression. We will focus on the criminal aspects of international humanitarian law. But it was very important to me to at least set the scene that whenever we speak international humanitarian law, the priority must be given to sharing the knowledge and to prevention. And this way, we will avoid having to use the courts. Then again, when people cross the line, when people go beyond what is acceptable into an armed conflict, then these people must know that they will have to answer and they will have to explain their acts and respond to justice, whether it is into an international court, such as the ICTY or Yugoslavian Tribunal, or whether it is in a national court of law. So, going over to the repression mode and to international criminal justice. Where did it all come from? Well, it started as far back as the year 1439, that is 1439, when you have the trial of Peter Agenbach. But I will not go that far back. Let me just bring you, for example, to the Lieber Code. The Lieber Code, of course, was a code which was written by a man called Francis Lieber, who was a lawyer within the in the United States. And he wrote this code to be applied in the U.S. War of Independence, that is, in the United States. And despite the fact that this code was meant to apply in what some people call an internal conflict, only in the United States, it is nevertheless the ancestor or the origin to many of both the Geneva Conventions or also of the additional protocols in terms of the wording that is used. And there, for the first time, we find positive law, we find regulations that will say to an individual, you cannot do this or you cannot do that unless, and if you do, you will be liable to the death penalty. I would like to read you one example coming from the Lieber Code, and that was Article 25 of the Lieber Code of 1863, and I would like to read this provision of the Lieber Code to you. It goes as follows. The unarmed citizen is to be spared in person, property, and honor as much as the exigencies of war will permit. All wanton violence committed against persons in the invaded country, all robbery, all sacking, even after taking a place by main force, all rape, all wounding, maiming or killing any inhabitants are prohibited under the penalty of death. This is the first time we have a regulation that really and clearly outlines if you do something like that, you have crossed the line of what is acceptable conduct during an armed conflict, and you are liable to the penalty of death. This was the origin. Of course, we do not have any examples that I can share with you this morning of people who were tried under the Lieber Code. This is why we move on to World War I. And as you know, after World War I, which concluded with the Treaty of Versailles, which was signed in 1919, and the Treaty of Versailles called for the establishment of a special court. Special court, the aim of which was to try the Kaiser of Germany, the ex-emperor of Germany, who was to be accused of committing many atrocities during the First World War. Unfortunately, in order to try the Kaiser, a request for extradition was addressed to the Netherlands, where the Kaiser had taken refuge. And unfortunately, the Netherlands refused to extradite the Kaiser, and no trials took place after the First World War. That brings us then from 1919 all the way up to 1945 and the end of the Second World War, which, as you know, gave rise to the creation of two international military tribunals. The International Military Tribunal for Nuremberg and the International Military Tribunal for Tokyo, or, as some people say, for the Far East. In both cases, a number of accused were put under trial by, if we speak about Nuremberg to begin with, this was a tribunal created by the United States, the Soviet Union, Great Britain, and a little later on by France. 24 accused, the architects of the Nazi policy in Germany, were put under trial by the Nuremberg Tribunal. Out of the 24 accused, 12 were sentenced to death, 9 were sentenced to jail, either for life or for a lesser term, and 3 were acquitted. as far as Tokyo goes, there was also in the Tokyo tribunal 28 accused who were accused of having committed atrocities, whether it was against soldiers of the United States Army or also against soldiers in China. So this is what we have in 1945. We have two international military tribunals. Most people know about these two tribunals. I'm sure you have heard before Nuremberg, or you have heard before also the Tokyo Tribunal. However, what most people do not know is that following World War II, there were up to 4,000 war crimes trials which took place. Now, these trials, beyond those which took place before the Tokyo and Nuremberg Tribunal, were organized by states, and for example, some trials were organized by the United States, by Canada, by France, by the Soviet Union, and by a number of other states to put under trial all those who had committed war crimes during the Second World War. And this led to, I believe, the last well-known trial took place up to in 1951. We then move on to also an important date in terms of international criminal justice, and that is 1948. In 1948, the newly created General Assembly of the United Nations adopted Resolution 260. And in this Resolution 260, there was a call, or at least the mention of the existence of an international criminal court. That is 1948. Unfortunately, for a number of reasons, which of course would not help us today in terms of going over how international criminal justice works today, this international criminal court was never put together, was never born. And until 1998, as I was telling you at the beginning of my presentation, when the Rome Statute for an international criminal court was adopted by over 100 states who signed this treaty. The treaty was to come into force once 60 states had ratified the treaty signed in Rome, and this happened in 2002 in the month of April. And in accordance with the terms of the statute, the International Criminal Court now exists and has entered into force on 1 July of this year. So, just as a recap, you can see that we move from the Lieber Code and the first provision about facing justice if you commit a crime. We move to First World War and the Treaty of Versailles, good intentions but never worked. We move to World War II with Nuremberg, Tokyo, and national war crimes tribunals, which have put under trial a number of accused, and then silence right up until 1998 and the creation of the International Criminal Court. Now, as you know, and of course this is our main topic for today, we move to looking at before the creation of the Rome Statute, there was two ad hoc tribunals were created. In 1993, the International Criminal Tribunal for the former Yugoslavia, or Yugoslavia Tribunal, was created. And in 1994, another International War Crimes Tribunal was created, this one in Rwanda, the International Criminal Tribunal for Rwanda, to address the genocide which had taken place in the Great Lakes region in Africa. So this concludes basically the introduction. This is where it comes from. Now what I would like to share with you is really to move to the ICTY, or the Yugoslavia Tribunal, and tell you a bit as to why it was created, how it was created, and of course to discuss with you the functioning of the tribunal. How is it that this tribunal works in The Hague? As you know, this tribunal is in fact located in The Hague, in the Netherlands. So, moving on to the establishment of the tribunal. What happened exactly to convince people to create this tribunal? Well, there was this conflict in the former Yugoslavia, and because the conflict was taking place right in the heart of Europe, the international community wanted to do something to stop the conflict. Now, if the international community had intervened quickly when in the early stages of the conflict, which began, as you know, in 1991, when Croatia declared its independence from the former Yugoslavia, if the international community had intervened quickly at that time, maybe it would have been possible to stop the conflict and for the international community to really take command of the situation. Unfortunately, it is not so easy, and for a number of reasons, the international community's response waited a number of months, and by the time they were ready to take action, it was too late to stop the conflict by military force. Or stopping the conflict by military force entailed sending too many soldiers abroad. And that's why they decided instead to focus on peacekeeping. And of course they created peacekeeping mission. The better known of the peacekeeping mission was the UNPROFOR, or the United Nations Protected Force in Bosnia. As the peacekeeping efforts were taking place, the news coming from the former Yugoslavia was that a number of atrocities were committed, even though there were some peacekeepers, some blue helmets as they are called, present in the former Yugoslavia. The international community was looking for a way to respond, a way to look active, and a way to show that it was doing something about the conflict in the former Yugoslavia. This is when the idea of creating a tribunal initially came about. For the first thing that was done, of course, is the Secretary General of the United Nations decided to send to the Balkans a commission of experts, which was called the United Nations Commission of Experts. This commission was sent to the field with a very clear mandate: find out if indeed atrocities are being committed, and report back to the Secretary General as to whether the creation of a tribunal could help putting an end to the commission of such violations. At that time, the 5 people were selected to be on the commission. They went to the field. They indeed reported back and saying that yes, atrocities are being committed. Atrocities appear to be committed by all sides to the conflict, and indeed the creation of an international criminal tribunal would help in putting an end to the violation. This led to the Security Council adopting Resolution 808 in February of 1993, and basically saying, Mr. Secretary General, we now want to create an international criminal tribunal to address the situation in the former Yugoslavia. Please report to us soonest with a statute under which we could create the court. The Secretary General went to work with the help of the Commission of Experts, but also with the help of members within the Secretariat of the United Nations. And it led to the adoption of the statute of the International Criminal Tribunal for the former Yugoslavia, and that was on the 25th of May 1993. The ICTY was born. What is very important to know is that, of course, the tribunal was created by the Security Council. It was created under Chapter 7 of the Charter of the United Nations, which, as you know, calls for measures to restore peace and security into any given area. So the tribunal was considered to be, by the Security Council, a measure intended to restore peace and security in the Balkans. Now, the statute at that time was comprised of 34 articles. It was very thin in terms of the law to be applied, in terms of how to create the tribunal physically, how to really put this body, this institution together, and to make it work so that people would be actually tried by the tribunal. At that time, many commentators were saying the tribunal is just an idea of the international community to look good, and that the international tribunal will never work. Well, this was not counting on the first people who worked at the tribunal. And here, of course, I must mention two names. First is the first president of the ICTY, the Italian judge, Judge Cassese. Judge Cassese, along with the first prosecutor of the tribunal, Mr. Richard Goldstone, who was from South Africa. These two people worked non-stop, and their efforts never diminished in order to make the tribunal work. And in the end, their efforts paid off in that a first accused was brought to the tribunal. First accused was, the name of the first accused was Tadic. Tadic was a kind of what we call a low-level perpetrator. He was a civilian who was very well known in his local area, and because he was very well known, and because he was kind of took part into the planning or the war planning in his local area, he also had access to the detention camps in his local area. And while he was in the detention camps, he committed many atrocities, and he tortured some prisoners and committed many crimes, for which in the end he was convicted. Now, I mentioned, of course, Tadic, but the reason I mention this first accused is that because he was indeed the first accused, there were many challenges brought by the lawyers involved during, of course, this first trial of Duško Tadić. And this is what I'd like to share with you a bit, is the early legal issues, and of course also the challenges which were faced by the tribunal very early in time. And the first such challenge, if you just, excuse me, the first such challenge was basically the validity of the creation of the ICTY. Immediately the defense, or the people representing Duško Tadić, filed a motion to the judges saying this tribunal does not have the jurisdiction because it was not created validly and is not an established court of law in accordance with the generally accepted principles of law. So this is the first issue which came up, and the chamber, which was of course at that time decided to render a decision, basically saying that no, the tribunal was created validly, that it was an established court of law. The accused nevertheless appealed this decision, and this gave rise to one of the single most important decisions for the tribunal, the Tadić interlocutory appeal. Interlocutory appeal, of course, is when you appeal a decision during a trial, which must be answered before the trial can continue. So the defense filed their interlocutory appeal, challenging once again the creation of the tribunal. The appeals chamber rendered its decision in October of 1995, and of course this opinion was written by Judge Cassese, the president of the tribunal, and he basically confirmed that the tribunal was validly created because it was open to the Security Council to create subsidiary organs under Article 25 of the United Charter. This means that the ICTY is a subsidiary organ of the United Nations Security Council. Now, the Judge Cassese, also said that it was possible for the appeals chamber to pronounce itself on the creation of its own existence. And that was based on a German principle called la compétence de la compétence. Basically, a tribunal can pronounce itself on its own constitution and the validity of its own constitution. So, ICTY is created under Article 25 of the Charter as a subsidiary organ. What is very important about this is that because the tribunal is a subsidiary organ, the decisions rendered by the tribunal are binding on all states the same way that any decision issued by the Security Council would be binding on all states. Now that is very important because when the tribunal says someone must be arrested, then all states have the duty to execute a warrant of arrest which would be issued to them by the tribunal. Finally, of course, Judge Kesese and the appeals chamber also confirmed that the tribunal created under Chapter 7 of the United Charter was indeed a proper mechanism to restore peace and security in the Balkans, and that it was open to the Security Council to create such a body, and that as long as the Security Council remained independent from its subsidiary organ, there was no problem with the tribunal being both independent and impartial. The tribunal, of course, in its early days faced a number of additional challenges. One of these challenges was the confrontation between continental law and common law. These are the two, as you know, main legal systems of the world. Now, when the statute was drafted by the employees, by the United Nations in the Secretariat, it was very much drafted as a common law statute. Later on in this presentation, I will basically explain to you the difference between common law and civil law. Basically, when you have common law, where you have on one side the accused, on the other side you have the defense, and in the middle you have a judge who sits like kind of a referee or kind of as an arbitrator who has not much to do in within this trial taking place before him. Whereas in the continental law, this is the law you know best, as you know, the judge has a much greater role to play, and the judge can really influence the process. Now, when initially this trial started, very quickly conflicts arose between those who were from a continental law background and those who were from a common law background. Now, what is interesting to say is that, in my view, this of course is in my personal view, neither system is well suited for the purpose of international criminal law. If you take common law, for example, it may be very good for the rights of the accused. It may also be very good for the prosecution, and because they may cross-examine and they may question every witness, and they get to lead the evidence. However, in the system of international criminal law, where the conflict took place years ago, where the victims are by hundreds and not by a single body, where you do not have the bodies of the victims, where the scene where the crimes took place is more than 5,000 kilometers away, where you have to send investigators to dig up those bodies and to find the evidence, and more importantly, to speak to witnesses who are scared of speaking because they know that if they speak up, they may very well be killed in return, or at least have their families put their families into trouble. So when you have a system like that, you cannot have a common law system because this system is asking for too much. On the other hand, where you have continental law, allowing the judge is also not possible in the circumstances, and I could get much more into the detail, but it doesn't really fit what is necessary. So, what I would like to say to you is that the biggest difficulty of the tribunal, this merger of two legal systems, one of its major drawbacks or difficulties, can actually be its single most positive aspect, because we are actually creating in The Hague a new system which will become international criminal justice of tomorrow. Moving on quickly to another challenge which took place with respect to the creation of the tribunal, and that is the confrontation between criminal law and international law. You heard me at the beginning speak about international humanitarian law, and of course this is international law. Yet again, when we speak repression, we speak international criminal law. So there is not a conflict, but at least a confrontation between those who say that criminal law must prevail and those who say no, humanitarian law is the aim of those trials. When you put both together, it did create some difficulties at the beginning, but now people understand that you cannot neglect neither international humanitarian law nor international criminal law, and that again, this new system of international criminal justice must be a merger of both. Moving on to the fourth and last challenge which the tribunal faced in its early days, and that is a very important challenge. This one deals with the principle nullum crimen sine lege, and that is, in other words, the legality principle. Now, the legality principle says you cannot be accused of committing a crime unless you knew that such behavior was a crime, that such behavior existed as a crime. So, let's look at the situation. The tribunal was created in 1993, but the conflict began in 1991. So, the Security Council was in a very bad situation where it could not create law. Well, really, it did not want to create law, but it had to create the tribunal on the basis of existing law. This is why the tribunal rapidly used both the Geneva Conventions, which were adopted in 1949, and also used the Hague Conventions, which dated back to 1907, in order that the crimes incorporated in the statute of the ICTY would be crimes which existed in 1991, so that no accused could come forward and say, well, you are accusing me of a crime which did not exist at the time it was committed by the accused. This challenge, of course, this was again challenged in the Tadic trial, but is also the object of regular challenges. Most recently, one of the defense teams did introduce a challenge before the court, challenging the jurisdiction of the tribunal and saying that no, you cannot put a certain accused under trial for command responsibility because the crime of failing to prevent or to punish, I will get back to that later on my presentation, as a commander, did not exist when you say it was committed by the accused. So this is an ongoing challenge, and every time the tribunal must be convinced that the law they are working with existed at the time the crimes were created. And that, of course, is called the legality principle, and it is indeed very, very important. I would like now to move on to the mandate of the International Tribunal. Why was it created other than for, of course, for the international community to appear to be doing something about the conflict in Yugoslavia? Well, you can look at it strictly from a legal point of view. And then we look at Article 1 of the Statute of the ICTY, and basically it says the mandate of the tribunal is to investigate, to charge or to accuse, to put under trial, and where people are found guilty, to punish. This is the stricto sensu, or in strict terms, the mandate of the ICTY. and it must everything that the tribunal does must be focused towards that mission. That's from a legal point of view. But the legal point of view, you cannot ignore that it is not alone. There is also reality in the Balkans. Why did we create the tribunal? Of course, we wanted to basically stop violations from being committed. And in some respect, this did work, but as other people will say, it failed because, for example, the tribunal existed when the massacre of Srebrenica took place, or the tribunal existed when the conflict erupted in Kosovo. So, in some respects, it had success. In other respects, it did not have success. But what is the aim of the tribunal? Not the aim or the mission, the work that has to be done by the ICTY, but what must the work of the ICTY yield as a result in the Balkans? And of course, it must yield a number of things. First, it must bring back peace and security in the Balkans. Second, it must allow for reconciliation amongst the people to take place, to allow those people who have been fighting each other, not only in this conflict but in previous conflict, to try once again to live together. And last but not least is the issue of deterrence. By putting people under trial, you deter, of course, the same people from committing crimes, but you also deter everyone in the world that they seeing, watching the work of the tribunal, and saying, well, we know now that if we commit a crime, we will have to face criminal justice. So it is a very important deterrent effect. Now, all this put together, there must be a finality. There must be an aim to the work of the tribunal. And this aim, of course, is the end of the mission, which is really reconciliation and the return of peace and security in the Balkans. I'd like now to share with you quickly the jurisdiction of the tribunal. What is the tribunal doing in terms of what can the tribunal do? Well, first of all, the jurisdiction of the tribunal, we must look at the temporal jurisdiction. The temporal jurisdiction meaning when must a crime have to be committed, must have been committed for the tribunal to have jurisdiction. And this is, it starts in 1 January 1991, and it is open-ended until the Security Council will decide that peace and security and reconciliation have returned to the Balkans and that the work of the tribunal is no longer necessary. So it is open-ended, but it starts on 1 January 1991. As far as the geographical jurisdiction, or where must the crime have been committed for the tribunal to have jurisdiction, such a crime must have been committed on the territory of the former Yugoslavia, on the complete territory. Now, this is why, even though a crime could have been committed in Croatia as an independent state, or even a crime committed in Kosovo, they are all fall under the jurisdiction of the International Criminal Tribunal for the former Yugoslavia. So after 1 January 1991, in the former Yugoslavia, then we look at what kind of crimes. Of course, these crimes deal with international humanitarian law, and they are divided up into 4 categories. These 4 categories are first Article 2 of the Statute, which deals with grave breaches of the Geneva Convention. Now, grave breaches of the Geneva Conventions, as you know, because I mentioned it at the beginning of my presentation, these are the most serious crimes, breaches which you find in the Geneva Conventions, and also for someone to be found guilty of such an offense, two things must first be established. First, such a crime must be committed during an international armed conflict. And second, the crime must have been committed against protected persons. As you probably know, if you look in the Geneva Conventions, in whether it's Geneva Conventions 1, 2, 3, or 4, there are provisions which say who are the persons which are protected by the conventions, if they are the object of a crime, and if there was an international armed conflict, then you may have a grave breach. This is Article 2 of the statute. Now we'll get back to that because, of course, the issue of the qualification of the conflict is indeed very important. I'd like to move on right away to Article 5 of the statute, which talks about the crimes against humanity. Now, crimes against humanity, of course, is a concept which was born closely before the end of World War II, and this was, of course, to address crimes committed on a massive scale or widespread and systematic against any civilian, whether they were from your own state or from another state. And this is what was the most important distinction between crimes against humanity: the massive character and the fact that it's any civilian population. Now, when we look at crimes against humanity, again, some basics must be established before someone can be found guilty. And that is first the nexus with an armed conflict. The nexus with an armed conflict means that the crime must be committed during an armed conflict. Now, you will note that it doesn't matter whether the conflict is an international armed conflict or non-international armed conflict. What matters is that there must be an armed conflict. Now, if we look back to the Nuremberg trials, and if we look back at customary international law, we find that it is not even necessary to have a link with an armed conflict. A crime against humanity can be committed regardless of whether or not it was committed during an armed conflict. But for the ICTY, this was put into the statute as being the will of the Security Council that the tribunal in The Hague would only address violations committed during the conflict which took place there, which started in 1991. So the ICTY statute is actually even more restrictive than the state of customary international law with respect to crimes against humanity. The other, of course, the other thing that must be established is that of civilian population, and we will get back to that a little later when we look at the case law of the tribunal as to what interpretation was given to the notion of civilian population. Moving on to Article 4 of the statute, this is called genocide. And genocide, of course, is very often referred to as being the crimes of crimes. The crime that will be where you have a series of acts which will be committed, these are crimes, committed with the intent of destroying in whole or in part a group based on either racial, religious, national, or ethnic group. If you have someone, a group being killed or acts being committed for this specific purpose, then you may have genocide. Genocide that we know of today, we have for the first time a ruling, for example, about what happened in Rwanda in 1994 was indeed a genocide. So that is Article 4 of the statute. I then go back a little to Article 3, which deals with war crimes. And war crimes are basically, it is in the words of the appeals chamber of the tribunal, it is a residual provision. Basically, Article 3 war crimes was there to make sure that any existing crime in 1991 would fall under the jurisdiction of the tribunal, and that no one would evade or escape justice and the case being punishment. So it was like a residual provision. Now, war crimes, of course, can include violations to the Geneva Conventions, which are not grave breaches, which means that when you want to prosecute under Article 3 of the statute, you will have two choices. Either you can try someone for a crime committed pursuant to conventional law, a provision of the Geneva Conventions, or for a crime committed pursuant to customary international law. If it's for conventional law, well then, depending on where the conventional law is, if it is a Geneva Conventions, then you will have to prove that the conflict indeed was international in character. If it's something committed against Common Article 3, which is an article which is common, as you know, to the 4 Geneva Conventions, then you will not need to show that the conflict was international. Now, if you look at the fact that the other thing about Article 3 is that if you move to the second aspect, which is trying someone pursuant to customary international law, of course you will have to prove that under customary international law, the conduct or the crime committed by the accused did exist and was recognized by states as existing under customary international law. So just to recap in terms of what type of crimes you have in the statute of the ICTY, you have Article 2, the grave breaches to the Geneva Conventions. You have Article 3, the residual clause, or anything that does not fit into Articles 2, 4, and 5. And then you have Article 4, which is the genocide, and Article 5, which deals with crimes against humanity. All these crimes fall under the jurisdiction of the ICTY. Okay, then we move on to, now that we know what type of crimes we can prosecute, and of course if you read the statute you will find out exactly what is and what is not included. For example, the crime must have been committed for someone to be found guilty, and not an attempt, or usually is not a crime under the ICTY statute because it is not included. Moving on to who can be prosecuted by the tribunal. If we go back to the Nuremberg Tribunal, of course you had both persons were put under trial, but also organizations were put under trial. No, so in this case, what is important is that for the ICTY is that only persons can be put under trial. The ICTY is limited to individual criminal responsibility. It deals solely with what is called the jus in bello and not the jus ad bellum. Whereas whoever was right in launching attacks or in beginning the war is beside the point for the ICTY. What is important for the ICTY is to look at persons who have committed crimes and ensuring that these persons will be brought to justice. So, because you only have individual criminal responsibility, then I'd like to share with you to basically highlight the fact that there are two types of individual criminal responsibility. The first one, of course, is a personal involvement. Someone who is personally involved in the commission of a crime. This can be the person who actually committed the crime, but it can also be the person who either planned the crime, ordered the crime, instigated the crime, or even aided and abetted in the commission of the crime. All these could be explained in many more detail, but basically a commander who plans an operation and the operation produces violations, then he may be guilty because he planned the operation. That's a bit more complicated, but for our purposes this morning, let's just remember that under Article 7.1 of the Statute of the ICTY, you can be put under trial if you are an individual, and that is, of course, for committing, planning, ordering, instigating, or even aiding and abetting in the creation of a crime. There is a second type of individual criminal responsibility, and that is command responsibility or superior responsibility. Superior responsibility, and that is a very, I was going to use the word funny, but it is not funny at all. It's much more tragic. Command responsibility is where a commander, and because we begin with the fact that, with the idea that command responsibility was initially created for military commanders, you have a commander who fails in his duty to prevent the commission of war crimes by his troops, or if he knows that his subordinates have committed crimes and he fails to punish them for committing such crime, then that commander is liable to be found guilty under Article 7.3 of the statute and to be punished accordingly. That is, of course, command responsibility is very important. When I give lectures on the conduct of hostilities, I always remember to mention the specific role played by commanders with respect to international humanitarian law. And what I tell the people when I give these lectures, I say, on one hand, you have the government, which has negotiated and has entered into agreements or has ratified, for example, the Geneva Conventions or the additional protocols. Once you have the states has adopted at least have ratified these treaties, then they will adopt the implementing legislation, which is ensuring, as you know, that the contents are included in their own national law. So this is what these states must do in order to ensure that they can prosecute these crimes. I'd like now to move on to command responsibility, or to continue into command responsibility, because command responsibility is when you have a commander who is, of course, where he has soldiers under his command. These soldiers commit crimes. If the commander is not involved into the commission of these crimes, yet it is his duty to make sure that the soldiers apply and abide by the law. And if the soldiers do not abide by the law, and he fails in his duty to prevent, then he may also be guilty of a crime, even though he did not commit the crime himself, or he did not want the crimes to be committed. Now that's very difficult, but it is also understandable, because only the commander can fill the gap between the state who signs the treaties, ratify the treaties, adopts implementing legislation, and then you have the soldier in the field. In between the two, there can only be one person, and that is the commander. The commander has tremendous powers, and they use these powers, and if they don't, well then, by not using these powers, they may fail in their duty and be also guilty of a crime. Three things are necessary for a commander to be guilty, and that is, first of all, he must, of course, a superior to subordinate relationship must exist between the person who committed the crime and him. And second, he must have had reason to know that either a crime was about to be committed or that a crime had been committed. And three, he must have failed in either preventing or punishing someone who he knew had committed a crime. Now, what is very important to remember within the ICTY, and I've said that again, but I must stress that it only deals with individual criminal responsibility. It does not deal with the jus ad bellum. I say that again because it is important to say that we only deal in The Hague with individuals. When an individual face a trial, they face trial in their individual capacity, and not as a member of their government or as a member of either a state or an ethnic group. Let me move on now to the structure of the ICTY. Now, we have seen that the ICTY has jurisdiction starting in 1 January 1991 over all of the territory of the former Yugoslavia for 4 types of crimes, and either for people who have taken a part in the commission of a crime or who are in their capacity as a commander have failed to prevent or punish. So we've covered all that. One last thing I'd like to say, of course, is that this issue of superior responsibility applies not only to military commanders, but it also applies to civilian leaders. Now, once you have all this, then you say, well, how does it work? How does it physically, if you come to The Hague to visit the tribunal, what will you find? Well, you will find 3 organs. The tribunal is divided into 3 organs. First organ is the office of the prosecutor. Office of the prosecutor is divided again into 2 parts. On one hand, you have those who investigate the crimes, and you have those who prosecute the crimes. You have the investigators, which come from all over the world, and these people go and visit the crime scenes, get the witness, get the statements from witness, bring back the information to The Hague, and then this will allow charges to be drafted and for a trial to take place. Then, of course, you have the lawyers who will present the evidence in court, and they will basically prosecute the case. So two main sections or divisions within the office of the prosecutor. But the office of the prosecutor also includes some section with some specialist section. For example, the appeals unit, or the appeals which will introduce or present the evidence and the law in all appeals before the tribunal. And you also have sections that deal with military analysis, so to allow those lawyers who do not have that military background to understand how the crimes were committed and whether or not it was a violation. And also a section that deals with the leadership. It is very important if you want to try to put under trial the politicians, the highest holding the highest of offices in the state. You must understand the leadership structure in that state, and the office of the prosecutor as a division or a unit that deals just with that. Now, the head of the office of the prosecutor is the prosecutor herself. For the past 3 years, this person has been Mrs. Carla Del Ponte, and she is from Switzerland. She is independent in her work. She will decide who will be accused, and she can get no instructions either from national states or from the Security Council. And she insists on performing her duties in an independent way. The second thing you will find in the ICTY is the registry. The registry takes care of 2 things. The registry, on one hand, takes care of the logistics of the tribunal. It will take care of the budget. It will take place of the housing. It will take place of making sure that everything is there so that the tribunal can materially work. But the registry also has a very important function, and that is to be the judicial manager of the tribunal. And that is a very complex undertaking. Let me give you just one example. In the trial of Dario Kordic, which ended about a little more than a year ago. In this trial, there were, at the end of the trial, more than 100,000 pages of transcript. There had been more than, I think it was 2,500 pieces of evidence were introduced. And the chamber had heard more than 300 witnesses. All this material, which is gathered at every trial, must be managed, must be processed, and must be kept. And all this is the role of the registry. The registry has indeed an important role. It will also deal with, of course, the security of the information, and it will also deal, another of its tasks is to deal with the victims and the witnesses, to ensure that the man or the woman in the Balkans who have never left the Balkans are able to come to The Hague in a completely different environment, come to The Hague and testify as to what they saw and what happened to them during the conflict. The third organ of the tribunal is chambers. Chambers, of course you understand, I refer to the judges of the tribunal. But of course, not only the judges and their staff. There are at the ICTY today 25 judges. These 25 judges are divided into 3 trial chambers at the first level or the first instance. Each trial chamber is composed of 6 judges, and each is divided into 2 sections, allowing it to conduct 2 trials at the same time. So 3 trial chambers, 6 judges for a total of 18. Then you have an appeals chamber composed of 7 judges, which brings, of course, the total to 25. The appeals chamber, although they have 7 judges, only 5 sit at any one time or for any appeal. This allows 2 to be to 2 more, which increases the capacity of the appeals chamber. So, with all this machinery, the tribunal is able to lead at the same time, simultaneously, 6 trials and appeals simultaneously. And that is very important because initially the tribunal had only 11 judges, whereas now they have 25. This is part of measures which have been undertaken by the current president of the tribunal, Judge Claude Jorda from France, who has done lots of work in order to convince the Security Council that he needed more judges in order to terminate the work of the tribunal more quickly. So, this, of course, completes the way the tribunal is built: Office of the Prosecutor, Registry, and Chambers. Now, you may ask yourself, and I'll be glad to answer this question for you, where is the defense? Well, unfortunately, when the statute was drafted, the defense was not intended to be an organ of the tribunal. But the defense, is it important? A lot of people ask me in my new capacity as a defense lawyer, how can you do that? How can you basically represent or even defend someone who has committed atrocities? Well, the issue is that this is the basic basis of the legal system, and that is the presumption of innocence. And everyone is presumed innocent until a trial has taken place. Now, later on, when I speak about the statistics, you will see how important the role of defense is. And to use another example, if we go back to Nuremberg, 24 accused, 3 were actually acquitted. Now, this is 1 out of 8. You need people to put up the case and to ensure that before anyone is found guilty, a case has been made beyond a reasonable doubt that they are guilty of an offense. So how does the defense work at the tribunal? Well, most accused do not have the resources to pay for a team of defense counsel, and therefore they become known as indigent, and therefore the tribunal pays for their defense counsel. And accused will get 2 defense counsel, will get also the services of a legal assistant and 1 or 2 investigators. This will become the defense team, and of course this small team of 5 will have to fight, of course, the office of the prosecutor, which has much more means. But of course the work is different. What is mostly important, however, is that there must be equality of arms. Equality of arms is not having the same number of resources for the prosecutor or the same number of people for the defense. However, Equality of arms entails that an accused must have the necessary resources to have a good defense, full answer and defense. Once this is ensured, then we have what we call equality of arms. Recently, the Defense Counsel practicing before the ICTY have formed, after many years, an association of Defense Counsel, which will kind of become, even though it is not under the statute, will become the fourth organ of the tribunal. Let me talk about now, as time is running out, about the functioning of the tribunal. Well, first, I said at the beginning of the presentation that the tribunal was kind of limited to a statute which only contained 34 articles. Well, of course, the judges, what they did, and one of those 34 articles calls upon the judges to adopt rules of procedure and evidence. And the judges have done that very early in the game. As soon as they arrived in The Hague, they started to write these rules of procedure and evidence. Basically, the rules that they will apply to make sure that trials can take place. Now, these rules can be amended at any time by the judges sitting in plenary. This was a source of critique for the tribunal, because normally, if you are the legislator and if you adopt the laws, you should not be the one who is using the law, because then you can just shape the law the way you would like to use it. So this was a source of critique for the tribunal. Nevertheless, this was a necessary phenomenon. It was necessary for the ICTY judges to have this power, because the statute, this was a new system that they were creating, and the initial rules of procedure and evidence were not sufficient, or were not clear enough and complete enough to address all issues which could take place during a trial. That's why this power was important. And of course, as long as any decisions taken by the judges to amend the rules does not create a prejudice to an accused, then it is not a problem. This, of course, is a difference when we compare with the International Criminal Court, where the judges will not have the power to amend their own rules of procedure and evidence. A quick word on the functioning. How does it all work? Now we've seen all of the mechanism. How does it work? Well, the first thing that happens, of course, is the indictment process, and the prosecutor will say, yes, I've got evidence, I want to indict or to charge an accused. Before she does so, the indictment will be reviewed by what we call, we'll go through an indictment review. This is people within the office of the prosecutor trying to sit together and to argue the case to ensure that they have enough evidence that it will not be frivolous to charge a person. Then the judges of the tribunal will have to confirm the indictment. So really, even though the prosecutor lays the charge, it is the judges who decide, yes, there's enough evidence for a trial. Once that takes place, it triggers what we call either an arrest warrant is given to the state where the accused is believed to be. The state is bound and has to abide and to execute the arrest warrant given to it by the judges. The accused is arrested. The accused will be transferred to The Hague, where he or she will be under provisional detention during the trial, and then either released at the end or sent to another state. What happens at that time is that there will be an initial appearance, and as we have in common law, the accused will plead guilty or not guilty. This will trigger the pretrial procedure, where the defense and the prosecution, with the help of the judges, will try to weed out all that is unnecessary in a trial to focus on the real issue and make the trial shorter. Once the pretrial is over, as soon as judges are available, you will have the trial itself, which should last no more than 1 year. Unfortunately, there has been some slippage recently. Sometimes it is understandable when you have accused like Milosevic, but when you have accused which are of a lesser involvement, then those trials should never last more than 1 year. In following the trial, you may have an appeal, and the history has shown so far that for every single trial or judgment issued by the tribunal, every time there has been an appeal, except for one, and that was when an accused called Yelisic had pleaded guilty for war crimes and crimes against humanity, and of course he did not appeal that conviction, even though he later appealed a verdict. The prosecution appealed a verdict given by the chamber that he was not guilty of genocide. So basically that's what it works. And I'd like to move on now to what is important to make all this work, and that is state cooperation. I've mentioned at the beginning that pursuant to Article 29 of the United Nations Charter, states are obligated to abide, or they are bound by the decisions of the tribunal. But the tribunal has no police force and no one to do these arrests. So state cooperation is important, because if the accused are not arrested, then we cannot have any trials. But states also will provide evidence to the tribunal, because many of them were present in the Balkans. States will also, when a trial is over and someone has been convicted, may, if they have signed an agreement with the tribunal, will host someone for the duration of his prison term after a trial. Finally, you have some states which will also cooperate with the tribunal in terms of relocating witnesses who are in danger if they go back to the Balkans. I will now probably end this presentation, at least the first part of this presentation, with some of the statistics. We are now in 2002. 2003 is fast approaching. The tribunal will soon have been in existence for 10 years. So after almost 10 years, what has the tribunal done in terms of work? Well, the tribunal, first of all, we look at the budget. How much is this place costing? Well, the tribunal in 2002 will cost the international community 120 million American dollars. It's a lot of money, and the tribunal, and for that reason, the international community is right in expecting a lot from the ICTY. More than 1,300 people work in The Hague now. That is 1,300. It is a big machine. So, since 1993, the tribunal has done 16 trials. 34 accused have had a decision at the trial level, and out of these 34 accused, 29 have been convicted or found guilty, and 5 have been found not guilty. So 5 out of 29 is a ratio of about 1 to 6. That is 15% of the accused were found not guilty. This should show you the importance of having good defense counsel to ensure that someone who has not committed a crime is not found guilty. On the other hand, when a person has committed a crime, then he or she should be sentenced accordingly. So, when we look at the number of appeals, the tribunal has done 9 appeals so far, and 15 accused, therefore, have now a final determination of their case. More statistics, we now have 42 people are in detention in The Hague, and 26 against whom charges have been laid are fugitive and have not yet been arrested. And that is, of course, a major problem for the tribunal. Also important to mention is the fact that we have 8 accused which are now on provisional release. Moving on quickly to what's in the works for what's in the future for the tribunal. Well, the prosecutor says she will indict at least another 35 people. This will be important because this will have an impact on the time necessary to complete the mission of the tribunal. On the other hand, the president of the tribunal would like to take some of these cases and to transfer them to the Balkans to help those states regain their sovereignty by trying their own criminals. And of course, you have the International Criminal Court, and the International Criminal Court, which of course now is in operation. Two different mechanisms. They cannot try the same people unless some mechanism is developed. However, what is important to note about the International Criminal Court is that it will also be costing lots of money to the international community. So how long can you have the ICTY costing 120 million, the ICC costing again millions of dollars, and also the International Criminal for Rwanda also costing millions of dollars? How long can you have all these tribunals working when, and I did not mention that earlier, you have now a new International Criminal Tribunal in Sierra Leone? Well, that's a lot of international criminal justice. So it is important to finish the work of the tribunal as quickly as possible. And the president of the tribunal, His Excellency Judge Claude Jardin, has been taking a lot of initiative to try and put an end to put an end to the work of the tribunal. And this is indeed very important. And if we can succeed in taking some of these cases and in transferring these cases to the Balkans and concentrating the work of the tribunal on the highest level accused, then the tribunal will have done its share. This is important because although the tribunal works for history, there is something much more important than history. If you take the trial of Mr. Karadzic, Mr. Karadzic's trial in 10 years will be good for history, will be good for law, but for the Balkans, it will not be good. A trial, Mr. Karadzic must be put under trial. He must be given the chance to put his case, and let's find out whether he is guilty or not guilty. This will help the Balkans. This will help to return peace and security in the Balkans. This will help the people to, again, have reconciliation in the Balkans. I hope this presentation answered most questions you have about the tribunal. As you can see, I could have continued for hours telling you about the tribunal and also telling you about the case law of the tribunal. But maybe this could be the object of a further presentation, going specifically into cases and going as to how the tribunal has contributed to the advancement of international humanitarian law. I thank you for taking the time to watch me speak to you on this camera. Once again, I must say this is the first time I have the opportunity to speak to a camera and to speak to what we say a virtual audience. I hope I did not too bad, and I hope that what is most important, I hope that you did get some knowledge that you were looking for about international criminal justice during this presentation. Thank you very much.